Good day everyone, we are the Group 5 together with my members, G.N. Pacamalan, Soledad Dutarion, Stephanie Bungo, Michelle Samante, Glenda Laurel, Abigail Tishu, and me, Maria Aubrey L. Fabre. Today, we are discussing about the Corporation Code of the Philippines, Batas Pambansa bilang 68, Title 14, 15, 16.
Hi everyone, I am Abigail Tishu from the SPE3A and I will be tackled about the Title 14 from Section 117 until Section 122. Title 14, Dissolution. In Section 117, Methods of Dissolution, a corporation founded or constituted in accordance with the provisions of this code may be dissolved either voluntarily or involuntarily. Section 118. Voluntary dissolution where no creditors are affected. A corporation can be dissolved by a majority vote of its board of directors or trustees. For dissolution, stockholders must own at least 2/3 of the outstanding capital stock. The certificate of dissolution will be issued by the Securities and Exchange Commission. Section 119, Voluntary dissolution where creditors are affected. A petition for dissolution of a corporation may be filed with the Securities and Exchange Commission if creditors are affected. A majority of the board of directors, trustees, or other officers in charge of the organization's business must sign the petition. It must list all claims and demands against it, as well as the fact that its dissolution was approved by a majority of investors. If the petition is sufficient in form and substance, the Commission will set a deadline for filing objections in an order stating the petition's aim. A copy of the order must be published in a general circulation newspaper at least once a week for 3 weeks. If no objections are made, the Commission will issue a decision dissolving the corporation and directing that its assets be distributed as justly as possible. The Commission has the authority to appoint a receiver to recover such assets and pay the corporation's debts. Section 120, Dissolution by shortening corporate term. According to the provisions of this code, a voluntary dissolution can be accomplished by modifying the articles of incorporation to decrease the corporate period. In compliance with this code, a copy of the modified articles of incorporation must be submitted to the Securities and Exchange Commission. The corporation shall be presumed dissolved without further actions upon approval of the altered articles of incorporation or the expiration of the reduced term, as the case may be, subject to the provisions of this code on liquidation. Section 121, Involuntary dissolution. The Securities and Exchange Commission can dissolve a corporation after receiving a verified compliant and providing sufficient notice and hearing on the reasons set forth by current laws, rules, and regulations. Section 122, Corporate liquidation. Every corporation in England and Wales has 3 years after it would have been dissolved to remain as a body corporate. The time limit is in place to allow it to prosecute and defend cases brought by or against it, as well as settle and close its business. It is not for the purpose of sustaining the business for which it was founded. The corporation has the authority to transfer all of its assets to trustees for the benefit of its investors, members, creditors, and other stakeholders. No corporation may distribute any of its assets or property until it has been legally dissolved and all of its debts and liabilities have been paid.
Good day, everyone. I am Glenda Laurel from BSBE 3E. I will be discussing the section 123, 124, 125, 127. Section 123. A foreign corporation is one form organized or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after it has obtained a license to do so. Section 124. Application to existing foreign corporations. Every foreign corporation which on the date of the effectivity of this code is authorized to do business in the Philippines under a license therefore issued to it, shall continue to have a such authority under the terms and conditions of its license. Section 125. A foreign corporation applying for a license to transact business in the Philippines shall submit to the Securities and Exchange Commission a copy of its articles of incorporation and bylaws certified in accordance with law. The application for a license to transact business in the Philippines must include the following: a statement of the amount actually paid in and such additional information as may be necessary or appropriate to enable the Securities and Exchange Commission to determine whether such corporation is entitled to a license.
Good day, everyone. I am Soledad Notarian, and I'm going to talk over about Section 126, 129 to 131, and also the Section 133. Section 126. This section talks about how and what are the possible actions you must take to get a license. In order to conduct a business in the Philippines, you must get a license. The granting of license. If the Securities and Exchange Commission is satisfied that the applicant has met all the criteria of this code, as well as any other specific laws, rules, or regulations, the commissions will grant the applicant a license for those purpose or purposes described in the license. If the real market value of the securities on deposit has declined by at least 10%, the Securities and Exchange Commission may compel the deposit for additional securities. The interest or dividends on these securities placed shall be payable to the licensee. Such securities will be refunded if the licensee ceases to do business in the Philippines.
Section 127. The resident agent of a resident foreign corporation is one appointed on whom summons and other legal processes against the company may be served in all actions or other legal proceedings, or may be either an individual or a domestic corporation lawfully transacting business in the Philippines, provided that in the case of an individual, he must be of good moral characters of sound financial standing.
Hi everyone, I'm Michelle Lapad Samanti from BSBE 3E. I'm going to discuss section 128, 135 until 138. Section 128 Resident Agent Service of Process. The Securities and Exchange Commission require as a condition that any foreign corporation file with the Commission a written power of attorney, designating some person on whom any summons and other legal processes may be served in all actions or other legal proceedings.
Section 129. This states that any foreign corporation validly conducting business in the Philippines is subject to all laws, rules, and regulations applicable to domestic businesses of the same type. This includes, but is not limited to, laws governing business formation, organization, and dissolution. Section 130. This means that the Securities and Exchange Commission must be notified within 60 days of any changes to a foreign corporation's article of incorporation or bylaws. The submission of such a document has no effect on the company's ability to conduct business in the Philippines for the stated purpose or purposes. Section 131. This stated that whenever a foreign corporation operating in the Philippines changes its corporate name, it must obtain a new license. An updated license can be obtained by submitting an application to the Securities and Exchange Commission. The application must be approved by the competent government agency in the applicable cases.
Hi everyone, I'm Stephanie Bongo from BSBA 3A. I will be discussing the section 132, 139, 141, and 142. Section 132. A foreign corporation license in the Philippines merges or consolidates. Any domestic corporation may combine or consolidate with one or more foreign firms. Such a foreign corporation must file with the Securities and Exchange Commission if it is permitted by Philippine law and the legislation of incorporation.
Section 133. It says that there will be no foreign corporation conducting business in the Philippines without a license, or its successors or assigns shall be permitted to maintain or interfere in any action, suit, or process before any Philippine court or administrative agency according to the law. In the Philippine courts or administrative tribunals, any valid cause of action recognized under Philippine law may be initiated against such a firm.
Hello, I am Maria Aubrey Labis Fabre from BSBA 3A. I am going to discuss the section 134, 143, 144, 145. Section 134, Revocation of License without prejudice to other grounds provided by special laws. The license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the Securities and Exchange Commission. Any of the following can result in your license being revoked or suspended: failure to submit an annual report or pay any fees due under this code, any material matter in any application, report, affidavit, or other document filed by such corporation is misrepresented, any other reason that would exclude it from doing business in the Philippines.
Section 135, Issuance of Certificate of Revocation. The Securities and Exchange Commission, SEC, shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. The SEC shall also mail to the corporation at its registered office in the Philippines a notice of such revocation accompanied by a copy of the certificate. Section 136, Withdrawal of Foreign Corporations. A foreign corporation licensed to transact business in the Philippines may be allowed to withdraw from the Philippines by filing a petition for withdrawal of license. No certificate of withdrawal shall be issued by the Securities and Exchange Commission unless all the following requirements are met. Section 137, Outstanding capital stock means the total shares of stock issued under binding subscription agreements to subscribers or stockholders, whether or not fully or partially paid, except treasury shares. Section 138, Designation of Governing Boards. Non-stock or special corporation may, through their articles of incorporation or their bylaws, designate their governing boards by any name other than as Board of Trustees. The provisions of this code to the contrary notwithstanding, a non-stock corporation may designate its governing board by that name.
Section 139. incorporation, and other fees. The Securities and Exchange Commission is hereby empowered to collect and receive fees as authorized by law or by the Commission's rules and regulations.
Good day, everyone. I am GNB Pakamalan. This time, I will discuss the Title 16, Section 140, Section 146, until Section 149. Section 140, which is stock ownership in certain corporations. In Article 14 of the Constitution provides that the NEDA, or the National Economic and Development Authority, may set maximum limits on stock ownership in corporations deemed by it to be vested with a public interest. Maximum limits may be set by the Batas Pambansa for stock holdings in corporations belonging to individuals or groups of individuals related to each other by consanguinity or affinity or by close business interest.
Section 141, Annual Report or Corporations. Every corporation, domestic or foreign, lawfully doing business in the Philippines shall submit to the Securities and Exchange Commission an annual report of its operations. The report must include a financial statement of its assets and liabilities, certified by any independent certified public accountant. Section 142, Confidential Nature of Examination Results. All interrogatories propounded by the Securities and Exchange Commission and answers to them shall be kept strictly confidential. Results of any examination made by the Commission or by any other official authorized by law to make an examination of the operations, books, and records of any corporations.
Section 143, Rule-making Power of Securities and Exchange Commission. The Securities and Exchange Commission shall have the power and authority to implement the provisions of this code and to promulgate rules and regulations reasonably necessary to enable it to perform its duties hereunder, particularly in the prevention of fraud and abuses on the part of the controlling stockholders, members, directors, trustees, or officers. Section 144, Violations of the Code. Violations of any of the provision of this code or its amendments not otherwise specifically penalized therein shall be punished by a fine of not less than 1,000 pesos but not more than 10,000, or by imprisonment for not less than 30 days but not more than 5 years, or both. In this discretion of the court, if the violation is committed by a corporation, the same, after notice hearing, be dissolved in appropriate proceedings before the Securities and Exchange Commission, provided that such dissolution shall not preclude the institution of appropriate action against the director, trustee, or officer of the corporation responsible for said violation. Provided further that nothing in this section shall be construed to repeal the other causes for dissolution of a corporation provided in this code. Section 145, Amendment or Repeal. No right or remedy in favor of or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by any such corporation, stockholders, members, directors, or officers, shall be removed or impaired either by the subsequent dissolution of said corporation or any subsequent amendment or repeal of this code.
Section 146, Repealing Clause. Except as expressly provided by this code, all laws or part thereof inconsistent with any provision of this code shall be deemed repealed. Section 147, Separability of Provisions. Should any provision of this code or any part thereof be declared invalid or unconstitutional, the other provision, so far as they are separable, shall remain in force. Section 148, Applicability to existing corporations. corporation organized under the old corporation law may, notwithstanding the approval of their corporation code in May 1, 1980, continue as such. However, if such corporation is affected by the new requirements of the new corporation code, it shall have a period of 2 years within which to comply the code. Section 149. Effectivity. This code shall take effect immediately upon its approval.